trial that is happening. This is happening in nearby New Jersey. If you were familiar with the story, a tragic one at that, last August in 2024, hockey brothers Johnny and Matt Gaudreau were killed when they were riding their bikes. It was the night before their sister got married. The person accused of killing them is accused of being drunk, Sean Higgins. So right now, this is a trial, a final disposition conference and motions that's taking place in Salem, New Jersey. Let's go to that here live on Live Impact News on WCNC Plus.
That had been made. As Your Honor recalls, there was a phone call between the state and co-counsel with regard to a plea offer. Thereafter, we then received a written plea offer of 20 years. The state then said that plea offer of 20 years in writing was an error, that the plea offer then was a offer essentially of 35 years with regard. While researching that issue, and I'll agree that there's no motion, or will there be a motion to try to enforce a plea offer of 20 years, it became apparent through discovery outside of the courtroom, as well as through a simple search, that within the past year, there were at least three that we know of, plea agreements made by the same prosecutor's office with regard to individuals that were charged with the same thing, except in one case, in the October of 2024 matter, the driver in that matter had a blood alcohol level of a 0.22, almost 3 times that of Mr. Higgins, and also was smoking marijuana. I do believe also had a 3-year-old child in the backseat. Also hit a cyclist by going into the cyclist lane and had to be stopped by a fire truck as he kept fleeing the scene. In that case, that individual, I believe was in front of Your Honor, was sentenced to 7 years with 85%, based upon a plea agreement state. Prior to that, there was also a matter of David Thomas, which was Judge Lawhon, where there was a term, 1 year, was for a term of 4th degree assault by auto, where Mr. Thomas killed another motorist while 3 of his passengers and the first vehicle struck were injured. He had an open container in the car. And his blood alcohol level was a 0.156, double that of Mr. Higgins' alleged BAC concentration, and was traveling at a high rate of speed before that. Again, that was sentenced to a concurrent term of 4 years, each on a 3rd degree assault by auto and a 1-year term on assault by auto. So I do know that there was another matter of Stephen Krowski, who killed a motorist where he had a blood alcohol level of 0.122 and was traveling at a speed of 113 miles per hour before the crash, and 70 miles per hour at the moment within. And again, Judge, I do understand that this is a unique request with regard, and part of the reason behind it is, with all due respect, and understand there's cameras here, so it's a case where it's a little bit different, but justice is supposed to be blind. And it's supposed to be blind when we're looking towards a defendant or when we're looking towards a victim in a case. There should not be a special category because it's a high-profile case that state is treating this one differently than a case they had just a few months ago in this very court in front of Your Honor, with worse facts and circumstances. And it's the state's obligation. The prosecutor's office represents the state of New Jersey. This is not a civil case where they're representing the estate of the victims. I do understand there's victims here. And from the process that we've had thus far with regard to the issues with discovery and getting things moving along here, I do believe that it's proper, at least, and if the state does not want to turn it over and Your Honor does not want to turn it over, again, I understand I could easily continue to go through promise gavel and look at every plea offer that has been made. Not offer, let me repeat that. Every plea agreement that has gone through and been made with the same type of case, and as I cited in my motion and my notice for that request, I just, for the sake of clarity, would like to see what the difference was in a case where we are now seeking 5 times the amount than that of when a school teacher is killed and a 3-year-old child is in the backseat. I understand that this is not something that's normally requested. With regard to my brief, Your Honor, I did cite, though, one of the things that is very important in all trials, and as I'm sure the court is aware, because I do believe that last year I think there's a total of at least 5 jury trials that were heard in this county. Most cases, I'm assuming then, are resolved by way of plea bargaining. And how do we get there? It has to be something that is fair, even-handed, on the level playing field. And at least I understand that there is no one objective way of saying that every case is the same. I agree that there are certain aspects that go to the mitigating and aggravating factors that Your Honor considers and weighs at the time of sentencing. However, leading up to that, when it comes to the negotiation, we have a situation here where it does seem that 97% of all cases are resolved through plea deals in this state. And you have to have a mutuality of advantage here when it comes to both the state and the defendant. And when we have a situation where we're told it's 35 years, and then you receive in writing 20 years, like, no, that's a mistake, it's 35 years. And then you know, as a practicing attorney in this county, that other cases are going through it 7 years. There's an issue, and you have to say, well, what is being treated differently here? I understand it's 2 victims. If they said 15 years, if they said 20 years, I would understand that. But when we get to 35 years, which essentially, with all due respect, if my client were to stand up and represent himself in front of the jury and be found guilty, that's most likely what he would get anyway. So it's really not a plea bargain. It's a take it or leave it. We're going to trial on this. And I don't want to talk just about fairness to the defendant. I want to talk about fairness to the victim's family as well. Because when you put it in such a posture that you're forcing a defendant to go to trial, that then puts an additional burden on the state as well as the family of the victim, because for whatever reason, the state is not using the same playing field that they used in other cases. So again, if the state says Mr. Kleinberg could just as easily go through promise gavel and get it, and the court says the same thing, I'll do it, and it's fine, and I'll still use that, and I'll still negotiate in good faith, as I always have in this court and every other court in this state and other states I practice. I'm asking for it. The state has it. If they say it's equally accessible to me, I'll go through the trouble of getting it, and that'll be it, Your Honor.
I guess the question, Mr. Kleinberg, is, and you've been practicing law a long time, plea negotiations, you always get it all. And in response, typically there's a counteroffer. I know in your situations, defense is not prepared at this point to make a counteroffer. But just because a plea resolves at a certain number doesn't necessarily mean that was always the state's first offer. And it's an ongoing process. It's a give and take. As the tide shift, the offer shift. So the fact that they started out where they started doesn't necessarily mean they're going to end where they end, which to me then creates an issue as to what relevance there would be as to the final plea that's perfected on the record. In other words, some pleas where there was a 7-year plea on the record, the offer may have started at 35. I don't know where the offer started.
Mm-hmm.
So what relevance is there as to what the initial state's offer was? The state hasn't, at least Mr. Mester hasn't indicated he's drawn a line in the sand and said 35, take it or leave it. This is our best and final offer. And I'll let Mr. Mester speak.
Judge, we asked about that though, just so you understand. When you ask what's the relevance, when it does come to the plea bargaining, and as much as I like to hold my cards close to my chest, I'll show the cards right now. The idea is this: I believe it would be beneficial for both the state, and the state could show to the victim's family, hey, over the past 5 years, these are cases in our vicinage, which is what I plan to do, not just Salem, but in the vicinage, where there have been similar cases that have either been pled out or gone to trial, and this is what happened. My idea is, in this matter, to go through and put at least a list together where the state can weigh out and see the similarities and differences, as well as look at the mitigating and aggravating factors in this case, and explain as well as to the victim's family, this is why we're coming to this number. Again, if the state says it's just as easily accessible to me, I'll take the extra few hours and do it. I don't mind hard work. I'll do it. It's not an issue. That's the relevance behind it. That's the reason behind it, Judge.
Mr.
First off, I want to address, counsel indicated that there are victims here. There aren't victims here. There are victim survivors here. The victims are not here. They could not be here. And with regards to this motion, counsel knows that he has access to what he's asking for in Promise Gavel. There's no need for this motion. And the fact that he put facts on this motion in this very public case, drumming up similar cases, reopening wounds for these other victim survivors is a bit offensive and unnecessary. It is clear defense does not like the initial plea offer. If counsel does not like the initial plea offer, they can do what defense counsel does in every case in the state of New Jersey. They can tender a counteroffer when they feel they have enough evidence and have an argument to tender a counteroffer. In their brief, they cited 19 cases, federal or state cases, to support their argument for Your Honor to compel the offers. All of them deal with the actual pleas in those cases, not the offers in those cases. None of them require Your Honor to do what counsel's asking Your Honor to do. If counsel doesn't like the offer, they can tender a counteroffer. Now, with regards to what I do or don't advise the victim survivors, that's between me and the victim survivors. I've been with them for hours going over this case and what is entailed with this case. They are aware of what this case is going to be, one way or the other. So defense counsel doesn't have to do any of that. He doesn't have to worry about on his end. So that's fine. So I don't think Your Honor really needs to grant this motion. Again, if counsel wants to tender a counteroffer, He knows my phone number. He knows my email. He knows where my office is.
Thank you, Mr. President.
And Judge, once we have all the discovery, I mean, this is since
We're 6 months into it now. I'm hoping we have the discovery soon. We will be able to rationally, intelligently, and properly do a counteroffer with all the evidence at that point.
Thank you. I did prepare some notes after I reviewed both of your submissions in this regard. I'll make the following comments. Pleas that were taken in open court, typically a public record, we have in open. They're not protected as far as what the ultimate result was plea bargain. Once again, the defendant's free to obtain this information from court. Court has a mechanism by which the defense can look those cases up and find the nature of every single plea that was taken by the court. The state is in a good position to furnish that information, but I don't know that it has any relevance as far as ultimate outcome of the case with respect to whether you see it's clear it would never be admissible. Court counsel could never stand up in front of a jury and argue to a jury. Well, in State versus Smith, the state offered the defendant a 7-year sentence, but guilty to 7. But in this case, they only made us a 35-year offer. Everybody knows that obviously that doesn't happen in court. So the relevance would be merely, I'll call it for exploratory purposes to see what the state proclivities are in similar cases. But that's something, once again, doesn't fit the rule of evidence. It should be something the court will consider relevant in a hearing or a trial. And as counsel is aware, the court has to look at each case, a case-by-case basis, as does the state, as does the defense. Everything is predicated upon a certain set of facts and circumstances that emanate from an incident that occurred that result in a criminal charge being filed. They're all different. Not one is the same, like Snowflakes. So when we're looking at everything in its totality, I don't see that there's an adequate basis that's been established by the defense to tell the state to turn over this information. Once again, plea negotiations, as I indicated, are ongoing. The state makes their original offer. The defense can counter, at which point the state can come back with the second offer. The defense can then recounter. Ultimately, we see many cases get to the point where, based upon those ongoing negotiations, we get a resolution. There are, as Mr. Kleinberg pointed out, 3% cases in the state of New Jersey do end up at jury trial because, for whatever reason, the state and defense can't come up with a number that satisfies both sides. So under the circumstances, based upon everything that we're looking at, I'm going to deny that motion to compel. I don't think it's appropriate. I don't think it's proper. There's relevance. However, once again, it's free. Public record. Defense is obviously entitled to do their own exploring, find out any prior cases this court has heard or any court investigation. Find out what the offers were. And actually not what the offers were, what the ultimate perfected plea is. So for that reason, I'm denying that. At this point, we can move on to the state's defense's motion to dismiss.
Judge, we're going to have.
I'm just going to switch.
Sure, you can switch. Oh, yeah.
Judge, thank you, and good morning. Good morning to everybody in the courtroom. Judge, this defense's motion to dismiss the indictment. We submitted briefs on it, Judge. I'll frame the argument, or frame what the issue is here, and that is the state presented to the grand jury on December 11th, 2024, the charges in this case. And the original charges were of importance were the leaving the scene, but more importantly, the second degree vehicular homicide, death by auto, or reckless vehicular homicide. After the presentation, Judge, the grand jury returned a true bill for 6 counts, 2 for first-degree aggravated manslaughter, 2 for second-degree reckless vehicular homicide, 1 count of fourth-degree tampering with physical evidence, and 1 count of second-degree leaving the scene of a fatal accident. Judge, the first focus to frame this is on the presentation, the dismissal of the 2 charges or 2 counts of first-degree aggravated manslaughter and the 6th count for leaving the scene of a fatal accident, Judge. And the reason for that is, under State versus Hogan, there's an argument to be made that the state failed to present a prima facie case of each element of aggravated manslaughter, that the state failed to present a prima facie case for leaving the scene of a fatal accident, and that the state presented what's the court in State versus Curtis said, a distorted version of the facts by presenting only half-truths to the grand jury. And the grand jury, Judge, in the scheme of the criminal justice system, is the first step after charges for the state to move the case forward along. And it's an important function. It's one that's guaranteed by the Constitution to all defendants. They all have a right to have the case heard by a grand jury. And what is the grand jury's role, or what is the state's role, Judge? And that is, in seeking an indictment, the prosecutor's evidential obligation is to present the prima facie case that the accused has committed a crime. And nevertheless, in establishing a prima facie case against the accused, the state may not deceive the grand jury or present evidence in a way that is tantamount to telling the jury or the grand jury a half-truth. And I'm going to quote this, Judge, from State versus Hogan at page 229, and that is, the grand jury cannot be denied access to evidence that is credible, material, and so clearly exculpatory as to induce a rational grand juror to conclude that the state has not made out a prima facie case against the accused. If evidence of that character is withheld from the grand jury, the prosecutor, in essence, presents a distorted version of the facts and interferes with the grand jury's decision-making function. Judge, there's case law out there. There's an analogy that the grand jury is not only a sword for the prosecutor to move a case along, but it's also a shield to protect the defendants and the accused from overzealous prosecution or overreaching by the prosecution. So, Judge, let's start with the aggravated manslaughter counts, which are counts 3 and 4 of the indictment. The elements that the state needed to prove or present, not prove, Judge, but present to the grand jury of aggravated manslaughter is that the 1, defendant caused the victim's deaths, that 2, the defendant so recklessly did so, and 3, the defendant did so under circumstances manifesting extreme indifference to the human life. And those are 3 elements, Judge. We concede the first one, that the defendant caused the victim's death, and that's based upon the autopsy reports. That the defendant did so recklessly, and Judge, I'm gonna concede that just for this motion. The reason for that is, under the reckless vehicular homicide counts in 1 and 2, the recklessness element was that Mr. Higgins had driven under the influence, because there's that certain section in that statute that when somebody is driving in violation of that statute, 39:4-50, that rises to the level of recklessness, where a state could then prove a case for the second-degree charge of reckless vehicular homicide. But the third issue here, Judge, or the third element, is that the defendant did so under circumstances which demonstrate that the defendant's conduct was done so under circumstances manifesting extreme indifference to human life. And that's where we go the difference between a second-degree death by auto, where there's just recklessness or drunk driving, to a higher element or a higher crime or a more severe crime of aggravated manslaughter, which needs to take into account, Judge, the drunk driving or recklessness, and then recklessness that is so high that the defendant's conduct would probably have caused the death of another person. Not mere possibility. It rises up to the probability, Judge. And that's in State versus Curtis in the appellate division, Judge, from 1984. It's the risk that the defendant caused by his conduct, which is the factor. It's not what's in his mind. It's not his intent. It's not his intent to pass somebody. It's the conduct. When you look at it objectively and rationally, did the conduct rise to the level of extreme indifference to the value of human life? Here, the facts of the case, which have been brought out in court through motions, has been put out all over the globe in social media and also through the press, Judge. The facts are that Mr. Higgins was driving home from Taco Bell around 8:30 at night. It was dark. Judge, the evidence that we have so far in discovery shows that the two bicyclists were on the right side of the road riding their bikes on the shoulder. And the shoulder, Judge, is less than a foot wide. So it's not even really a shoulder. It's just the side of the road. As Mr. Higgins was driving, the speed limit was 50 miles an hour. There were two cars ahead of him, a Ford Focus and then a Ford Bronco. Mr. Higgins, as the grand jury heard, said that he was traveling about 30 or 40 miles an hour, or maybe 30 or 20 miles an hour, coming up because he thought the other cars were going slowly. And he sped up, as you see people often do to signal to the other people, you got a car coming up, you're not going the speed limit. He goes to pass the Ford Focus on the left lane, which was allowed, because Trooper Pope at the grand jury, the presentation said it was a dashed yellow line. So there's no extreme recklessness or any recklessness in passing that car, Judge, although witnesses said that it came up at a high rate of speed, but we don't know what the speed limit is. We know that the one car, the Ford Focus, was driving at around 50 miles an hour. Mr. Higgins passes on the left, and he tells the police, but it's not presented to the grand jury, that he went back to the right. The Bronco, the second car, had moved over into the left as Mr. Higgins was passing the Ford. So what he did was, not knowing what that Bronco was doing, he went back into the lane. The state presents this as he was trying to pass the Bronco on the right. However, what Mr. Higgins explained to the troopers was, that Bronco went left. I don't know if he was trying to stop me, not sure what he did, so I went back into the lane. And unfortunately, when he went back into the right-hand lane, Judge, that's where the two bicyclists were. And it was...
You're watching here live on Live Impact News on WCNC Plus. In court, the driver accused of killing two brothers the night before their sister got married in New Jersey.